I am Jason Broesder. I'm happy to be here. I've been a lawyer for about 26 and a half years. I've been practicing in Southern Oregon the whole time. My area of practice is elder law. So I do a lot of guardianships, conservatorships, estates, estate administration, wills, trusts, that kind of stuff. As Melanie suggested, I'm going to give general legal knowledge. I'm not giving anybody specific legal advice regarding your case because each case is different and the circumstances and the situation can vastly change the outcome of your case. But I'd like to give you some general thoughts on how guardianships, conservatorships, powers of attorney, wills, trusts, estate administration, that type of stuff, how it works. And so what I'm going to do is I'm going to first talk a little bit about powers of attorney, and then I'm going to briefly discuss advanced directives, then I'll get into the guardianships, and then wills and trusts. As I move from each one of those, I'll ask you if you have any questions. So if you have any questions, like after I finish talking about powers of attorneys, if you've got a question about guardianship, go ahead and hold on to that until I get to the guardianship because I may answer it while we're talking about it. So powers of attorney, and this is all part of what I do in my estate planning. I want to make sure that all of my clients have addressed who they wish to manage their affairs in the event that they become incapacitated. And typically that's done through a power of attorney. A power of attorney is something where I, the principal, appoint an agent, or what we would call an attorney in fact, that person needs the power of attorney, to act on my behalf in the event of incapacity, to take care of my legal, financial, tax matters, anything that I designate to them. Now, generally, what we do as attorneys, we do what is called a general, durable power of attorney. General means it's going to cover a lot of different issues. It's going to be as broad in scope as we possibly can make it so that the agent, this person whom I trust very much, can manage all of my stuff if I become incapacitated. Durable means it lasts even after I become incapacitated. So I must be competent in order to execute the power of attorney, to sign it. But if it's durable, then it's still in effect even after I become incapacitated. Okay, pop quiz for anybody who wants extra points. Are powers of attorney still good after I die?
No.
Correct. Powers of attorney are only good while I'm alive. The principal must be alive for the power of attorney to be good. It terminates on death of the principal. Obviously, the agent's not able to act if they die either, so both parties have to be alive for it to work. In Oregon, all powers of attorney are durable unless they state otherwise. Now, where to get powers of attorney? A lot of institutions have their own powers of attorney. If I bank at People's Bank, it may very well be that you go into People's Bank and say, I'd like to appoint my daughter as my power of attorney, and they'll say, oh, we've got our own form of power of attorney. It's got the People's Bank logo on it and everything, and it's the one that they prefer. So it's helpful if you use the institution's power of attorney. You may have to execute several powers of attorney, but the People's Bank one may only be good for People's Bank. So as a lawyer, I want, again, this very broad general power of attorney so that my daughter can manage my People's Bank account, my Schwab account, can sell my house, transfer my vehicles, all of those types of things. So it's a very powerful instrument. And that brings us back to, again, my trusted person. If you have any reservations or doubts about whether or not you trust your agent, don't sign it, because it gives them a great deal of authority. Now, they've got a responsibility to act, they've got a fiduciary responsibility to the principal, so they're supposed to act in my best interest only. But powers of attorney in the wrong hands can be misused and can be financially devastating to a principal who entrusts the wrong person. So all of that stuff is super important with the powers of attorney. They can be revoked just as easily as they can be signed. As long as I've got the same level of competency or capacity, I can revoke or fire my agent of the power of attorney. Formality-wise, powers of attorney do not need to be recorded. That's kind of a common misconception. Typically, the agent on a power of attorney will want to have the original document with what we call the wet signature, the original ink signature on it. And the formality in which it is signed or executed allows the same formality for the agent to use for any other underlying documents. In other words, if I sign a power of attorney but it's not notarized, it's still a good power of attorney, but my agent cannot then turn around and sign a document on my behalf that is notarized, right? So I have to have that same level of formality in executing the power of attorney as the underlying document. Does that all make sense, what I just said? All right, Melanie gave me a few things to go over, and I wanted to make sure that I got them all. Melanie, do you think I missed anything?
On the forms, you said
Yeah.
institutions have forms. If I wanted to draft my own, is there a place to?
The internet has forms. One word of caution I would use in preparing your own powers of attorney is that, I think institutions tend to be more critical of self-drawn powers of attorney. In other words, there's a format that most Oregon lawyers use that I think are familiar to a lot of financial institutions. So if you take a power of attorney that was prepared by a lawyer into a bank, the bank will likely recognize that a lawyer prepared that. What that tells the bank is that the principal, when they signed it, most likely had independent legal advice when they signed it. So it relieves the bank a little bit from any concern that maybe they didn't have the power of attorney explained to them properly by their son or daughter, or maybe they were coerced or something like that. So in the lawyer's office, like when people sign documents in front of me, I make sure that they're competent, and I try to assure myself that they're not being unduly influenced or coerced into signing documents. Obviously, I don't know what's going on, at home or in the car on the way over and that type of thing, but I have conversations with people that helps me to believe that my clients are acting under their own will and not somebody else's.
As a POA, can I represent somebody in the courtroom?
So powers of attorney frequently give authority to represent people in the courtroom, but again, if I'm a judge, I might be a little hesitant depending on what the agent is, the actions that the agent is taking. A lot of times, my powers of attorney, they allow people to sue and defend, to litigate, but I think a lot of judges would prefer something more formal, which would be like a guardian ad litem, because that's a more formal process, and it assures the judge that there's some oversight, some supervision going on there. So, and again, if somebody is going to litigate as an agent under a power of attorney, they're under a fiduciary obligation to make sure that they're acting in the best interest of the principal, and not that they're doing, their own bidding. Yes.
Ad litem?
Guardian ad litem. Yep.
A-D-L-I-T-E.
That means guardian for the case.
Oh,
Yeah.
got it. Okay, thank you.
It's specifically for litigation.
Mm-hmm.
Yeah. Okay, so that's powers of attorney, unless anybody else has anything else. Yes?
I do actually have two. So I've seen on powers of attorney where it's either effective immediately or effective upon incapacitation. So if it is, first of all, do you have a preference on
Yes.
what you advise?
Strong preference.
Strong preference, which is probably the
Effective immediately.
Okay.
Because effective on a triggering event would be what we call a springing power of attorney, which is it's not in effect until something happens. And usually that triggering event would be some form of incapacity. Here's the reason why. I think that if you have any concern about whether or not your agent is going to act in your best interest, it's better to find out if those concerns are legitimate while you're competent than after you become incompetent. Secondly is, I think that it's very difficult while you're putting roadblocks in the way of your agent from acting on your behalf. You say, well, okay, it's going to require a letter from my doctor or an order from the court before this power of attorney goes in place. Well, if it's an order of the court, you know that's going to be expensive, and I'm probably going to fight it if you think you need a court order. And if it's a letter from the doctor, it may very well be that my primary care physician doesn't want anything to do with turning my finances over to my daughter, who he or she may barely know, and would rather just practice medicine.
Sure.
So I think that I think there are no good reasons to do springing powers of attorney.
Okay.
And then you had a second question?
The second one is, and this is completely theoretical, but if you have given someone a power of attorney, effective immediately, and then you revoke it, how on earth can you possibly know where they have used
That's an excellent question, and it's a real problem. So the question is, if you give someone a power of attorney, you revoke it, you've also got an obligation to notify all third parties that might think that that power of attorney is still in effect. So one thing that I recommend is hold the power of attorney.
You mean you physically hold it? Or
Yes.
Okay.
If I'm the principal
You're holding
and
it.
my daughter is my agent, because even though I said all that stuff about the springing powers of attorney and it's no good and all that stuff, my expectation is she's not going to use it until she needs to use it. I don't want her going out and, putting my car on Craigslist the next day and saying, well, time to start selling dad's stuff, because I'm still driving it.
Right.
But what I want is, if I suffer a stroke, if I suffer from cognitive impairment or something like that, then I want her to come to my house, look in my filing cabinet where I've told her my original wet copy is, then grab it, then use it. That's essentially my springing part, which is she knows where to get it. And as long as I'm holding the original, I know that she hasn't taken it around to every bank in town and said, I'm my dad's agent now.
Right.
So, because once she does that, if I give her the original and she starts spreading it around, I've got to tell everybody that might reasonably believe that she's still my agent. Otherwise, that essentially lets them off the hook. If she goes into the bank, and even though I've revoked it, if I haven't notified the bank and the bank turns over some of my funds to her for whatever reason, the bank is not liable for that. It's my obligation to notify
So
them. That's a
essentially,
good
it's
question.
impossible to, if
It's-
that person has
Yep.
chosen
If
an
they've
alternate
spread it
lifestyle.
around, it's gonna be. I mean, I wouldn't say it's impossible, because, at most I might have 5 or 6 financial institutions that
Right.
are holding money for me.
Sure.
So,
Okay.
if I want to revoke it, I'm going to notify everybody that
Okay.
has my stuff that it's no longer any good. I mean, you don't have to notify everybody, because
Sure.
B of A has no interest in my power of
Gotcha.
attorney, because they don't have any of my money.
And then I'm sorry, that brings one more question
That's
to
fine.
mind. Often on powers of attorney, I see a third-party reliance
Mhm.
clause on there. So that third-party reliance, can you explain that?
Yeah,
for
that's
me?
an inducement to make sure that they will honor it. Powers of attorney, financial institutions don't love them.
Sure.
And so that third-party reliance is saying, if my daughter is showing you this power of attorney, you may rely on it. You don't need to call me. You don't need to call my doctor. You don't need to check in and make sure this is all still okay.
Okay.
We want you to rely on her giving you that, knowing that it's still good. So, and that's one of the other reasons why, again, I don't love the springing powers of attorney, is I feel like there are enough roadblocks in using powers of attorney as it is. Just adding one more, it just makes it more and more difficult. And when the time comes that I want my daughter to use my power of attorney, I actually want her to be able to use it.
Of course.
That's the whole reason for
Thank
it.
you.
Yep.
And I had a couple of questions.
Of course.
Yep. From time to time, there's folks that don't have any loved ones or someone that they trust in their
Mhm.
family, and was it Southern Oregon has agents, the bank? Yeah. Is
Yeah.
that something that, if you're incapacitated, how do you know that?
So, that's tricky. Well, you've got to put a plan in place before you become
Yes,
incapacitated.
okay, fine.
After incapacity is a
You
bad
can't
time
do
to do
it,
planning,
right.
right? So yes, there are a couple of trust companies here locally, and then there are other financial institutions that use them. Oregon Pacific Bank and D.A. Davidson have local trust officers, but your estate must be fairly substantial for them to take on
A
the
power of
role
attorney.
of power of attorney
Yeah.
or trustee or something like that. Otherwise, I think what you're referring to is local professional fiduciaries.
Yeah.
We call those geriatric care managers.
Oh, okay.
And we've got a half a dozen of them that they're really good, and you'd want to interview and make sure you get the right fit for you. The nice thing about the geriatric care managers or the private fiduciaries is you're going to get a personal touch with them.
Right.
They will be checking in on you and that type of thing.
Are they licensed and they have insurance?
So you'll want to check with
You
each
just
one
check
of them,
with
but
those
as a general rule, they're all going to have licensure through the
State.
National Guardianship Association. If they're going to be doing guardianships and conservatorships, if they have multiple of them, they have to get that licensing.
Gotcha. Okay.
As far as bonding, you can require them to get a bond specifically for yours. But again, that's an expense. If
Yeah.
they get a bond, then they
Yeah.
use your money to purchase the bond.
And let me just mention to you, Jason actually represents some private fiduciaries. So if you know somebody who's looking for a private
do that.
fiduciary, it would be a good idea to refer them to Jason or another lawyer, and just they can just say, hey, do you know a private, because they can refer you to,
Okay, good.
reputable people.
That's
Yeah,
excellent. Thank you, Ray.
And that is important.
Yeah.
And again, it is important to get out ahead of those. And I have lots of clients who come in and I ask them, ask them about their loved ones, the people in their lives that would take over. And either they don't have them nearby, they don't have children or adult children, or they don't have adult children they trust.
Right.
And so when you run into that, that's a good time to say, well, let's interview some geriatric care managers. Let's see if we can get somebody on board before it's too late. for
Right,
that.
and oftentimes I get the family member calling saying, my dad needs a power of attorney right now.
Yeah, right. So yeah, that's it's not
All the
uncommon
time.
for me to get calls where they'll say, I need guardianship and a power of attorney.
Right,
And
yeah.
I'm like, well, those are mutually exclusive.
Yeah.
If you need guardianship, you're saying someone's incapacitated. If they're incapacitated, they're not signing a power of attorney.
They
So,
don't know what
okay, advanced directives are basically like powers of attorney only for health care. And that's about it. It's
Okay.
a principal-agent relationship, and we do those, and everybody should have an advanced directive. It's the way to keep your kids from fighting about whether or not they should pull the plug, because you get to make that decision beforehand.
And where do you get those forms?
You can get them from the doctor's office, you can get them online. They are statutory forms. So Oregon, that's straight out of the Oregon revised statutes. The doctor's offices and the hospitals, in my opinion, are notorious for giving out like 15-year-old document forms and I don't know why. It's like they ordered, 5,000 of them back in 2015, and now they think that, yeah. So get the latest. The
They come in
latest
beautiful
ones are
folders.
really good. Pardon?
They come in a beautiful folder half
They
the
do,
time, too.
they do,
Yeah.
yes. So definitely, everybody should have an advanced directive, because you've got to tell the doctors who they should talk to about tube feeding and life support and end of life, yes.
And
Jason, do you know if Asante has a person where, like, an office where you can go and get assistance filling this out?
Typically they do. I think each of the hospitals have, I believe like they wouldn't be the discharge planners.
Like a
maybe
patient
intake,
representative or something?
Yeah, somebody like that. It would be their intake people. So if you've gone in for any kind of procedure in the hospital, they're having you fill those out like within 10 minutes of you arriving.
I
They
see.
want to make sure that they know who's going to have those. And everything else applies with the power of attorney too, where you can appoint someone, you can fire them, you can modify it and amend it as long as you're competent. And it's only effective if you're unable to communicate. Okay? So if you say, I don't want tube feeding, I don't want life support, and you're taking a nap and your kid's next to you saying, pull the plug, let's do this thing, you can say, no, I don't listen to him. I want to stay alive. So as long as you're competent, you can make those decisions. Okay, Medicaid planning is super complex if it's a married couple. If it's a single person, it's super simple. They have to have no more than $2,000 in cash, and Medicaid will take care of them as long as they meet the medical needs requirement. So it's got to be two things. You must require a certain number of activities of daily living to be provided to you, and you must be down to no more than $2,000 in cash in the bank. And then Medicaid will pay for your long-term care. It's a shame that Medicaid and Medicare sound similar because they're nothing alike. Medicare everybody gets when you reach a certain age. Medicaid is a needs-based benefit. So for a single person, it's generally not going to be an issue, the estate recovery, because I'm already down to $2,000. I don't really have stuff. But what happens is, say I suffer a stroke and my wife is still alive, there's a bunch of rules in place, and I'm not going to get into them right now, but they're what are called spousal anti-impoverishment rules, which allow my wife to still live in our home, still have a car, still have some money in the bank and so on, but allow me to still be taken care of by Medicaid if we meet these other financial and needs rules. But the state of Oregon keeps a tab. And so as long as I'm in that facility and they're paying for my care, they'll keep a tab. After I die, they'll send my wife a letter saying, we're sorry to hear about Jason's death, but you owe us X number of dollars. But they won't make her pay because she was my spouse. But when she dies, my daughter will get a letter saying, we're sorry to hear about your mom's death, and you still owe us X number of dollars. Just my amount, no interest, but going back however many years it was.
Mm-hmm.
That's going to come out of whatever my wife had at the time of her death. If she still had a house, if she still had some money in the bank, if she still had a car, the state wants to get paid back. That's the estate recovery. There's not a lot of ways around it. If she's an adult disabled child, or if she was living in the home provided, there's a few kind of, I wouldn't call them loopholes, but there's a few rules that kind of allow resources to be passed down to the next generation, but they're pretty rare, and there's a lot to that one. So that's probably all I'm going to say about the state recovery.
So call an attorney?
See a lawyer about that, yeah. The state, Medicaid's tricky. It's tricky because for whatever reason, some 25 years ago, I learned a lot about Medicaid. Lawyers don't intentionally learn a lot about Medicaid. I think it was because I was young and foolish. I'm like, oh, I'm going to study this. I was still fresh out of law school. And then the partners at the firm I was working at, they're like, well, why'd you learn all this stuff about stuff where people can't pay you to teach them? I'm like, that was a bad plan. But it's something that I still do. I don't give out my Medicaid advice for free, but typically it's a 1 hour consult. I charge $400 for 1 hour, and that's usually enough to get people headed in the right direction. So there, to all those partners that were telling me I should have never learned all this stuff. Anyway, what I meant by saying all that is, unfortunately, there's not a lot of lawyers, especially in Southern Oregon, that know a whole lot about Medicaid. If you're looking for referrals, I'd refer you to Jacqueline Bunick. She's a young up-and-comer and made the same mistake I did and learned a lot about Medicaid. She's excellent, and I refer as many of my Medicaid clients as possible to Jacqueline, so please feel free to call her.
There is also just, if you need to shuffle people off somewhere so
Yes.
that your time is better used, there's a gentleman, Terrell Blaylock.
Oh yeah,
in Grants
Terrell
Pass, you know him?
Blaylock over in Grants Pass, and he's a financial planner, and
Yes.
Terrell's excellent. He knows more than a lot of lawyers. He is also an annuity salesperson.
Indeed,
It's
yes.
important to understand where he comes from.
Yes.
With me, I come from $400 for 1 hour of my time. Terrell knows the rules, and he is helpful, but he will steer you towards getting
Absolutely.
annuities. Now, with Medicaid planning, those annuities are a real crucial part of Medicaid planning. So I've got nothing bad to say about Terrell. His knowledge is exceptional, but you do need to understand you're likely going to walk out of there with some annuities.
Sure.
And we'll probably need them.
Okay.
So, excellent, yeah. Terrell Blaylock and Joel Mitchell, or was it the other way around? Joel Mitchell and Terrell. And I think Joel's in
Joel
Florida or
retired,
something like that, yeah.
He
So,
left the game.
anyway, they're very good, yes. Okay. Guardianships and conservatorships. Okay, I'm not going to get a whole lot into conservatorships. If you don't have a power of attorney or a trust, there's a possibility you're going to need conservatorship if you've got money or assets that exceed $10,000 or so. Conservatorship is where you go to court. It's a protective proceeding where you go to court to get authority to manage all of my finances. Now, With the power of attorney, I gave that authority to my daughter. If I didn't do the power of attorney, my daughter is going to have to go to the judge and say, okay, my dad is financially incapable. That's what she has to prove by clear and convincing evidence that I am financially incapable. Then the judge says, okay, you're the conservator. I'm going to want you to post a bond, and you're going to give me an accounting once a year, and you're going to show me every penny you've received and every penny you've spent on behalf of your dad. So my daughter's taking on a real bookkeeping job. But there's court oversight. So there's some good, some bad. It's going to be more expensive, but my other two kids can also see what my daughter's doing because they get to review the accountings once a year. And in theory, I get to see what she's doing also because she has to give me a copy of those accountings. So there's some good and some bad about the conservatorships. That's the financial side of it. And that is if there is sufficient resources. Now, to seek out a guardianship or conservatorship, if my daughter prevails and becomes my guardian or conservator, I pay for it. I pay the lawyers and all of that stuff. So if she doesn't prevail, then she's on the hook for her own attorney's fees. Trying to think what else I want to say about that part. Okay, so let's talk about the guardianship. The guardianship's a little bit different. She still has to prove by clear and convincing evidence, but instead of financially incapable, she has to prove that I'm incapacitated. That's the standard. Incapacitated in statutes, ORS Chapter 125, means that I'm unable to receive or evaluate information and make decisions based on that information, essentially. So if she's able to prove that, then the court's going to appoint her as my guardian. She's going to be able to make medical decisions on my behalf, placement decisions on my behalf. She can, if I'm in a facility, she can tell them to mix whatever kind of medication I might need in my applesauce to help me calm down, whatever it is that she might need, which you can't otherwise do, right? You can't hold somebody in a memory care facility against their will. That's wrongful imprisonment. You can't medicate somebody without telling them. That's a battery. You can't do those kinds of things. But if there's a guardianship, you can. Because under guardianship, it's as if I'm a minor child. Because, and my daughter will do this to me one day, because I still remember when she was 5 years old and we took her to Dr. Murdoch's office for her pre-K checkup and he was giving her booster shots. She took off down the hall and she was hiding under his desk when we found her. So she still remembers that. So she'll definitely do whatever medical procedures she can on me when the time comes around. But it's the same thing. With kids, you get to choose if they go to school till they turn 18, right, Justin? If they go to school, you get to choose where they live. You get to choose, what kind of meals they're going to receive and all of that stuff. It happens kind of the same way around with the guardianship. The only major difference is when my daughter was a minor child, I was financially responsible for her out of my own money. If she becomes my guardian, she doesn't become financially responsible to me, but she is responsible to use my finances appropriately for me. Does that make sense?
Mm-hmm. And
Okay,
the
so
power of
she's
attorney
not,
won't do that at all.
power of attorney does not do that. And that's a really good question, because a lot of times people say, well, I've already got power of attorney, so I should be able to put my dad into a memory care facility. That's not the case. You can't give up your right to be able to move about.
It's imprisonment.
Yeah, that's right. It is. You've got fundamental rights, and the power of attorney is signing over your financial and legal rights, and you've made that decision. Conservatorship is where they take those rights from you. Guardianship is where they take away your rights to make actual fundamental decisions about your care and about where you're going to live and stuff. The thing with both guardianship and conservatorship, and this is something I really like that Jackson County has instituted of late, is once you get appointed as either an executor of an estate, a guardian, a conservator, any kind of fiduciary like that, you have to take an online fiduciary class. I believe it's $150, but they're really good. The classes are super helpful, and they actually really help us lawyers, because it slows down and helps the fiduciary go at their own rate to really learn what their duties and responsibilities are. It helps them to understand when there's a conflict of interest, because a lot of times people don't recognize that type of stuff.
Is that the same?
It might not be as detailed as what an attorney might say.
No, and it's identical.
Is it? Okay.
Yeah, it's identical. So we use, because it's a statutory form. And that's the guardianships, and similar to the probates, and I haven't gotten to that yet, but those are all statutorily pretty rigorous. And this is why I honestly have no idea how many pro se guardianships happen, but if somebody files a guardianship pro se and I end up getting involved because somebody wants to object, they're almost always a mess, because you must follow certain steps and you have to do them right, and you have to do them in the right order, and it's all jurisdictional. And if you don't, then you're going to go to the hearing and you're going to lose because you didn't do it properly in the first place. I'm not saying that you should use a lawyer just for the sake of using a lawyer. I'm just saying if you want to make sure you do it right, either be really well prepared and spend some time on the statutes, or hire a lawyer to do it, because if you don't, it's just going to be a train wreck.
What if somebody files a guardianship on me and I don't need one and don't want one? How do I object?
So the courts have made it really easy to make sure that a respondent or protected person is protected. Again, you don't have to be a rocket scientist to still not be incapacitated. A lot of negatives in that one. Yeah. So I don't know how that ended. I think it ended with a negative, so three negatives, yeah. If you're not incapacitated, you get this bright blue form in large font that says, I object. And all you gotta do is sign it and either give it to the court visitor, who's the person who comes out from the court to investigate. You can give it to them, you can mail it, you can even just call. It has the phone number on there, and you can call up the clerks and say, I object. My name is so-and-so and I object. And they'll set it for a hearing. And again, at the hearing, the burden is on the petitioner to prove by clear and convincing evidence that I'm incapacitated. And it's a pretty high standard of proof, which it should be. I would want it to be. You can also do temporary guardianships in the event of emergencies. They're not emergency guardianships, they are called temporary guardianships, but a lot of people refer to them as emergency guardianships, where you can get the guardianship in just a few days. But if there's an objection, you're going to have a hearing. You're supposed to have it within 2 court days of, and Jackson County Court has been really good about that lately, unfortunately, because I hate those. It used to be that even with the temporary guardianships, we would get objections and be like 3 or 4 weeks out, and it gives the lawyers all a minute to breathe. But yeah, when we get an objection in a temporary, then I'm canceling appointments and scrambling, but that's all right. I asked for it, so that's what I get.
So Jason, just a basic question. The guardianship is control of the person. The conservatorship is control of the money.
Assets, yep.
And if your parent loses capacity, you have to go to the court. You have to ask for both.
Unless you've got power of attorney.
Okay, but if you don't have
But
power,
again, power of attorney does not give up the guardianship,
'Cause that's
but it
imprisonment.
handles the conservatorship. That's
so if you don't have a
exactly
power of attorney, you have to ask for guardianship and conservatorship,
That's correct.
and then you have to file both the guardian's report and the
And the
conservator's
conservatorship
report.
accounting, that's
Okay,
right.
that was
So
my
that's
question.
for-
And to that point, Ray, in our office, typically, if we do just a guardianship, after we get the guardianship in place, after we make sure that the client's doing their class and they're filled in on how guardianship works, because guardianship's pretty straightforward, then we'll withdraw as attorneys. So then the court and the client or the guardian can communicate directly. Because if there are reminders for guardians reports, which again are fairly simple, nobody wants to pay us to receive a letter from the court, then forward the letter to them, then help them file a guardian's report, because you know that whether it's $400 or $500, $800 a year, that's money that they didn't need to spend, because all you have to do is fill in the blanks and bring it to the courthouse and mail a copy of it to the protected person. But if we do both guardianship and conservatorship, we'll always stay on the case, because conservatorship accountings are complicated, and most clients need a considerable amount of assistance with those. And so then we'll file both the guardian's report and the conservatorship accounting for them.
So basically what it comes down to is if you have a parent who's losing capacity and they have some means, it's really in your interest to get an attorney and not try to do a conservatorship.
100%, yes,
Yeah, okay.
yep.
Okay.
And most people, if they have means, they've already established a will with the power of attorney, or they've set up a trust. And so even then, usually we just need the guardianship. If you need guardianship and conservatorship, frequently it's because people didn't put any kind of plan in place. And that's why, again, planning ahead, and this is the theme to the whole thing, which is you gotta have a plan. And so, but you can't always avoid guardianship, because I don't know what type of person I'm going to be when I'm cognitively impaired. You know, I hope I'm one of those nice people that just likes to go to McDonald's and get a Big Mac and a shake. But yeah, I may end up being one of those people that holes up in my house and, you know, pushes the couch up against the door and says, I'm not coming out of here except with my boots up or something. I don't know. I hope I'm the nice kind, but we'll see, I guess. Yes.
So this question might take us too far off, so please just shut me down. But if, let's say you have an autistic person who is protected with guardianship, if that person is, how can they prove then to the court that they no longer need a guardianship?
Yeah, it's an excellent question. So I do a lot of those. I've got one right now where a child turning 18. The reason, you know, somewhere on the spectrum. I've done dozens of them. Once a child turns 18, parents don't automatically get access to medical records. They can no longer make medical decisions on their behalf, and there's a real tug depending on the relationship of the parent and child, depending on the child's desire to feel, you know, some of their own autonomy. Yeah. So the short answer to well, okay, first the reason why. A lot of parents want to because they want to make sure the child isn't going to be taken advantage of. Frequently they're going to be entitled to some Social Security income, Social Security disability income. They might be hanging around with unsavory sorts who might not have their best interest in mind, or might think that it's fun to mess with them, or who knows. So parents want to restrict their associations, and that might make the child resentful. I'm not a huge proponent of trying to help those children break that relationship, because I genuinely believe all parents want what's best for their kids. They may not actively find what's best for them, but generally they will. They'd need a letter from a doctor, basically. A letter from some healthcare professional that says, it is my assessment that my patient does not need a guardian, and that they're able to make their own decisions in their own best interest, their own healthcare decisions, whatever the case might be. Something like that would be very hard for me to overcome in court. I'd require a lot of proof to the contrary.
And if a guardianship is already in place,
So yeah,
How do
that's
you
an
break
interesting
that?
thing too. So say I've got guardianship of my autistic son when he turned 18, and then by age 25 he was tired of feeling like I had my thumb on him the whole time. So he went and got the letter, and he sent a letter to the judge, and says, here's a note from my doctor that says I'm right as rain. The judge sets it for a hearing, and the burden is now on me to reprove everything again. My son has no burden to prove that he's competent, which is how it should be, right?
sure. Yes.
The law should say we all have the right to make our own decisions, even if they're bad decisions. So every time we go back to court, the burden is on the petitioner, the guardian, to prove over and over again that I'm incapacitated. Now, that said, if I do go to court and I do convince the judge again that the guardianship is still necessary and that my son's still incapacitated, if he sends the judge another letter 2 weeks later, the judge isn't going to set it for a hearing again. But a couple of years later, maybe so. So I've had that happen. Yeah,
So we're
Melanie.
gonna, if you have any more questions, feel free to write them down, and we'll get them onto Jason, and we'll get the answers out to you. The last thing on guardianship, if you could tell us where we should get our forms, because we noticed that some counties like Jackson County don't have forms for guardianships of adults or minors.
Yes, I'm pretty terrible for this, Melanie, because I'm not a forms on the internet kind of
Should
guy.
we see an
But
attorney?
yeah, that's
May I
you
say
should
what
see
you've
an
been
attorney.
doing?
So Yes, Jackson County just has the Guardians report online. I don't know if any other counties have them online. My strong opinion is you shouldn't try to go this alone. I've got a whole big tool chest at home, and in theory I could build a house, but I would never, because it'd be dangerous for everybody involved. And I'm not saying that being a lawyer is as difficult as being a contractor, but I think that it's a good idea to get people who know how to do it to do this stuff. I don't fill my own cavities. I don't do my own mechanical stuff. I've got people that are good at that stuff, and I'm good at doing guardianships.
Yeah.
So I wouldn't recommend doing it on your own, because like I said, anytime I've seen somebody who does try it on their own, it's a mess. But I don't get to see the ones that go smoothly. So that's my disclaimer, is there may be a lot of them that go very smoothly that I just never get a chance to see.
Yeah, and there are some counties that have forms online, but they may not always fit the process, because every process is different in every county. So we want to be careful where we're looking for those forms, and also with minor cases, there's additional forms that are needed to be filed.
Minors are super tricky. Yep.
Yep.
Especially if their parents are around and they're going to object. You're dealing way more with family law type statutes than you are with, because the guardianships, ORS chapter 125 is really, even though minor children you can get guardianship and conservatorship under chapter 125, it is really geared towards the elderly. And once you're dealing with minor children, if there are parents involved, there are the statutory authority says that there is a rebuttable presumption that the parents are acting in the best interest of the children, and that's a lot to overcome.
Thank you.
Thank you.
So again, if you have any more questions on that topic, feel free to write them down. I'll get them from you, and we'll get them on to Jason. We're going to move on to wills, trusts, and simple estates.
Okay, so let's talk first about the differences between wills and trusts. First of all, if you don't sign anything, a will or a trust, but your assets are all payable on death or jointly owned or transferable upon death to somebody else, whether it's a spouse or children or something like that, you may not have an estate to administer. So if I go out here tonight and get hit by a bus, my wife, let's not put that. I don't think the buses are running this late. Are they running this late? Okay. Well, we'll keep an eye on me. If I do, my wife will not have to administer my estate. Everything I own jointly with right of survivorship with her. Okay? So there's no probate, there's no trust administration, no nothing, because it's all going to pass by operation of law to her. Similarly, then if my wife transfers all of our assets or puts them all in some form where they're transferable upon death to our 3 kids, then upon her death, her estate wouldn't need to be administered. Now, where that gets tricky is with real estate. Real estate's difficult. There are transfer on death deeds, but as a general rule, they're not very good, and I'm not going to get into why, because that's outside the scope. But it's difficult to have an estate that's just going to transfer by operation of law to your next generation if you own real estate. So if my wife still doesn't sign anything and she dies, then my 3 kids are going to have to either agree on who's going to be the administrator of the estate, or they're going to go to court and fight about who should be the appropriate administrator of the estate. And then the estate's going to get split 3 ways, because that is the law of intestate succession in the state of Oregon. Intestate succession is basically the default provision. It is what Oregon thinks my wife would want if she would have done something or said something about it. So since I'm married and we have 3 kids and all 3 of our kids are both of ours, if I died, intestate succession would say, well, it's all going to my wife because that's probably who Jason would want it to. Upon her death, it all goes to her 3 kids. Where it gets super tricky is when you've got steps and halves and blended and stuff like that. So, but that's essentially how intestate succession would work. And that would be required to go through probate for the real estate if we're going through intestate succession. Probate is the court process where typically, again, a lawyer is going to assist with helping the executor make sure that the bills get paid, that the publication takes place in the local newspaper, all creditors are satisfied, and then the estate is administered according to the law, which is split 3 ways. That's going to be typically if my estate exceeds $75,000 in personal property. Personal property includes bank accounts, vehicles, other personal items, and $200,000 in real estate. And that used to be a reasonable sum. I don't know if you can buy real estate in Southern Oregon for $200,000. So, yeah.
Wow.
So that would be what we would now call a simple estate. So it used to be a small estate. It's now you can administer it through what's called a simple estate affidavit. So if I die with a mobile home that's worth $50,000, and that's personal property, it's not real estate, and another $20,000 in the bank, and that's all I've got, then I'm under the $75,000 in personal property, and that can be administered with a simple estate affidavit. There's almost no court oversight, and a lot of times you don't need a lawyer for that. Do you have the simple estate affidavit on the court website?
Yes, there's a packet for that.
Wonderful. So that one can be done. But again, there is a statutory scheme that goes along with that. Notices have to be sent out. The state of Oregon has to get it. All the other beneficiaries of the intestate estate have to get it, and so on. So you got to make sure you follow the rules with the simple estate affidavit. But that'll get you access to the bank account. That'll allow you to sell the mobile home.
You don't get letters testamentaries with the simple estates.
Correct.
You just get the stamp.
That's correct.
the red
Letters
stamp.
testamentary only come with the probate.
Yeah.
And so that happens a lot of times. The bank will say, well, we need letters testamentary, even though there's only like $15,000 in there.
Yeah, all the
And
time.
so, yeah, all the time. So then I just go back and tell clients, well, just tell them they're wrong. Tell them they're wrong.
What's the
And
timeline or time frame for a simple estate type of deal?
excellent question, Melanie. So you cannot file a simple estate affidavit until at least 30 days after the person's date of death. And then again, there's a 4-month creditor period with the simple estate affidavit. And I will say, even when real estate was within that $200,000 mark, title companies hated simple estate affidavits. They still hate them. They don't love them. Simple estate affidavits have actually become super useful, though, in one way, and that is now a simple estate affidavit covers pour-over wills. So let's talk a little bit about trusts. So I covered wills and kind of talked about simple estate affidavits, and then I talked about intestacy, which is without a will. So a revocable living trust is an estate planning instrument where, again, my wife and I can set up a revocable trust, and we transfer all of our assets, usually our bank accounts, our investment accounts, our real estate, all of those things into the trust. And then upon our death, since the trust is still ongoing, our successor trustee, our daughter, takes over, and she can manage our estate, pay our bills, and distribute the estate without having to go to court, without having to go through probate, probably saving some money. One of the questions is that a good idea? And this goes back to my original talk of how well do the kids get along? Trusts work really well when the kids get along really well. They may not work as great when the kids don't get along really well because they're pretty informal. And so if my daughter is, if she's not trustworthy, maybe she doesn't tell her siblings about all the bank accounts that were in the trust and that kind of stuff. So trusts, they should be used in appropriate situations, in my opinion. I got off base a little bit with that, but yeah, go ahead.
You're talking about revocable trust. There's
Yes.
irrevocable trust as well.
So the trust, after my wife and I died, our trust became irrevocable.
No one
A,
can change it.
a revocable trust
Yeah.
becomes irrevocable at the death of the trustors.
I've also heard that there can be irrevocable trusts when people are still living.
There can be, but
Is that
there's
mostly in California?
Pardon?
I know that it's.
no, they exist, but they're unique and they're way outside the scope of what we're talking about tonight. There's a bunch of different types of irrevocable trusts. Asset protection trusts are not good in Oregon. Oregon is not an asset protection trust state. So if you think you're setting up an irrevocable trust to put your stuff in it so that if somebody sues you, they won't get to your stuff, that doesn't work here.
Oh, that's what you
And if somebody tells you that, they're selling you something. Okay. Let me get back to where I was. No, that's okay. Oh yeah, the simple estate affidavit. So it used to be back when we were doing estate planning and we would set up the trust, lawyers like myself worried a lot about making sure that we got all of the assets transferred to the trust, make sure we're super clear with our clients. You know, you've got to go to the bank, you've got to talk to your investment advisor and make sure all of your accounts, except for annuities and retirement accounts and insurance and some variety of accounts that we don't put in trust, but make sure those are all in the trust. We still do that, but I don't stay up at night worrying about my clients doing it anymore, because now I could set up a trust and say I've got my house in the trust, but I decide to sell my house and I buy another house. And when I buy the new house, I don't put it in the trust. Well, in the olden days, that would turn that house into a probate asset that we would have to use the pour-over will to transfer that house into the trust. Now, under the new simple estate affidavit statute, since the will is a pour-over will and the only thing it does is put assets into the trust, that falls under the simple estate affidavit, even if my house is a $1.5 million house, way over the $200,000 limit. Because the simple estate affidavit says, we're okay with that, you can transfer the house, you can transfer, I might have $500,000 in an investment account, and I can transfer the house and the $500,000 investment account through the simple estate affidavit into the trust. So that saves a bunch of money, it saves all of the fees and costs associated with going through probate. So that's one of the features I really like about the new simple estate affidavit rule.
If somebody, let's say, doesn't have barely anything but a couple thousand in cash in a drawer and personal belongings and a dog and a car,
Yep, there's
do they
not gonna
go through all this?
not gonna be an estate. No, I have that happen where people will call me up and they'll start talking about the cash and the Velvet Elvis and you know how they've got credit card bills and all this stuff, and I'm going, well, do they have
Assets?
more assets than debts? Oh no, they've got way more debts than assets. I said, well, it's an insolvent estate. Which I do. I'm like, grab the Velvet Elvis and lock the door. You know, so you can't take the money and run, because that's the creditor's money, and but the creditors are going to have to fight it out for that.
So you pay off the bills, whatever you can.
I tell
Yeah.
them forget about it, because once you do that, because there's a hierarchy. If
Who do you
that's
pay first?
yeah, that's the problem. Is who you pay for, and then it ends up being proportional. Then you pay all those proportional, and then you get a letter from the Oregon Treasury Department saying, well, you owe us $30,000. That's coming out of your pocket because you paid all the wrong people first, because the Treasury Department's the highest
Okay.
priority. So I say don't mess with it.
And we found out there's not a big checklist for these kinds of things either. Is there
Now
anywhere
it's
you
in
could
it's
go
in
to-
the it's in the statute ORS
Just the
like
law?
1113. Yeah, well, now you can get on any AI and ask them, you know, which
Could be a checklist.
and you're probably going to get a pretty good one. I'd check a couple AIs just to make sure they don't mess it up, or just get a citation and then check the statute.
Give it
But
away ourselves.
it'll walk through like the
Teaching that.
priority of who gets paid first. So, but yeah, if it's one of those where we know we've got a ton of creditors and very few assets, I suggest to people not even get into it, because once you start, then you've got an obligation to do it right. And then if you keep coming back to me and asking me, am I doing this right? Then by the time all's said and done, they're going to pay me more than the money that they found in the drawer, and it's just not worth messing around with it.
And if somebody wanted to object to or contest a will or anything like that,
So contesting a will, the two primary ways you can contest a will or a trust is by alleging that the testator or the trustor was either not competent, that they didn't understand the nature of what they were signing, or that they were acting under undue influence.
The motive.
Those are two allegations that are very easy to throw out there and very difficult to prove. I can't tell you how many times I've had people call me up and say, well, my mom signed a will, but the doctor said she had Alzheimer's. I'm like, well, Alzheimer's is not a disqualifier. It's a diagnosis, and it means something, but there's no law that says that the day the doctor says you've got Alzheimer's is the day that you no longer have the right to enter into contracts, sign a will, or what have you. It all goes back to what we were talking about.
Yeah.
There's a lot of gray area between a diagnosis and actual incapacity. And there's lucid intervals. You can have somebody who's got fairly advanced, moderate to advanced dementia, and sometimes they'll check in and you'll have this conversation that's just amazing. And you can sign during those lucid intervals.
And that would be something you have to file like a pleading for.
You'd have to file a pleading for it, and again, it's going to be a long road to hoe. And if you hire a lawyer to do it, you get the pleasure of paying for your lawyer and a portion of the other lawyer that's fighting against you, because the executor or the trustee is using trust funds or estate funds to defend the trust or the will. So you don't know unhappiness until you've been in court paying for a bunch of lawyers all at the same time to fight for and against you. The other one is undue influence. Undue influence seems like it would be easy, but again, we're all influenced all day long. People influence our decisions. My wife has a great deal of influence over the things that I like and don't like. Sometimes I wonder if I even know what I like and don't like. But that doesn't mean it's undue. Undue means she's replacing what I think I like with what she likes. And I'm pretty sure she hasn't done that. I'm not positive, but I'm pretty sure. And so to unduly influence somebody, you need to make them do what it is that you want, not what they want. And that's usually with the undue influence, you can tell, because then we've got what we call the lucky child and the unlucky children, right? It's like, well, why did she love her one son that much more than the rest of the kids? And the kids are all like, I don't know, he was just nearest to her or whatever. But then maybe he was the one that was actually taking care of her for the last 10 years of her life. So it's not easy to prove. And I'm not saying it's not worthwhile. I'm just saying there's got to be a lot of circumstances to the execution of the estate plan.
And probably a good idea to talk to an attorney.
Yeah, good idea to talk to an attorney. And again, if it was an attorney that prepared the will and the trust, it's going to be that much harder to overturn it. So it's important to, these are things where it's important to have a third party advising someone.
Do you guys have any more questions about this topic?
Which topic?
All of the
Wills,
topics.
trust,
Wills,
estate.
trust.
And then, did you have anything else you wanted to share?
No, I think I've overshared.
That's wonderful.
But that's why I think it's important to have that neutral third-party professional advising the clients.
Like an attorney or like
Exactly like an attorney. Yep. Nobody else should be giving legal advice, including banks, but they love to give bad legal advice. For all you bankers out there. All right. I think that's it for me. Are we all tired?
Awesome, Jason.
Thank you for your